friends, welcome back to my channel, WSIB Truth Matters with Joe Machado. So this is the conclusion of this three-part video series where I talked about a number of topics. In the first video, I told a little bit about my story as an injured worker, my own experiences. The second video, I talked about some of the major differences with the implementation of Bill 162 in January of 1990 and the implementation of Bill 99 in January of 1998. Essentially, those two being the biggest differences to the WSIB system in the last 30 years or so. I also talked a little bit about my concerns about the $1.5 billion that WSIB has decided to give back to employers, and also with respect to how the unfunded liability was eliminated, the tactics that were used that I believe to be, that have been extremely detrimental to injured workers and continue to be so. So anyway, with this last video, I'm going to talk about the fraud charges that the WSIB brought upon me back in 2015 and what has transpired since then. I know that there's been a lot of talk and a lot of questions roaming around for the last few years about what happened. As you may know, Machado Professional Paralegals Corporation, which is my former company that I started and built over a period of over 25 years. It became one of the largest firms in Ontario representing injured workers exclusively with the WSIB. And the WSIB in previous years have made several attempts to get rid of me. And I can certainly appreciate why, because we were costing them millions of dollars. I was able to fend off those attempts relatively successfully. In some ways, I thought it was a bit of a compliment. They obviously considered my firm a worthy opponent and an organization that was very effective in helping and representing injured workers and getting for them what they're rightfully entitled to under the law. But there was nothing that I could be pleased with or consider a compliment as to what transpired in 2015 and thereafter. So anyway, in the spring of 2015, I received calls from several clients, and they expressed concerns that they had been visited, or in a couple of instances, these individuals from the WSIB were actually there at their home. So the client called and was able to reach me right away, nervous, obviously, and indicated that a couple of individuals from the WSIB had shown up at the house unannounced. And if I was aware of it, I said, no, I'm not aware of it. Clients, we always informed our clients to let us know if they received a call or a visit from someone with the WSIB or claiming to be with the WSIB. We always advised them to get in touch with the office so that we could, first of all, vet the authenticity of the call or who was trying to visit them, to ensure that it was someone that was actually with the WSIB, and then let them know whether or not they should go ahead with the call or speaking with that person. And we always made it a point of letting them know that, you know, you are represented. You have somebody who's representing your case with the WSIB. They are aware of it. Our authorization form is on file, and they should know better. But in any event, sometimes they'll try to do these things. And so it was important for us to let the client know that while it wasn't out of the ordinary, that they should contact us first. So with respect to this particular visit, I indicated to the client to ascertain if they were with the WSIB. So asked them if they could provide the claim number, and if they were able to do that, then asked them to provide a statement as to the nature of their visit. And so the client did that with me on the phone, and the two gentlemen were able, one of the gentlemen was able to provide the claim number, and also indicated that they were there just to ask questions about the client's claim. So the client asked me if he should proceed with the interview, and I said, well, listen, I mean, you have nothing to hide. You know your claim better than anybody else. So if you feel comfortable going ahead with this meeting, that's fine. Or if they would like to speak with me on the phone right now, I could speak with them. I'm available for that, but it's up to you. So anyway, he decided that he would go ahead with the interview. So after about an hour, I got a call back from the client, and so I said, well, how did it go? He said, well, you had a lot of questions about you, your firm, and recent information that had been submitted to the WSIB on my behalf. And I said, okay, what information? And he said, well, it was information that I had requested from Canada Revenue Agency that you'd requested to address my earnings calculation. I said, okay, well, that's fine. I mean, that's information that's coming from a government agency, and it's normal that we do that. So I have no issue with that. And then he said that they were concerned that there was some inaccuracies with the information provided. And I said, well, I'm not really sure what inaccuracies would that be, but they have the information in their hands. It was submitted to the WSIB. And if they have any issue with that information, then they can address it either with me or with you via a letter or whatever action they decide to take further. I'm not really sure what they're doing, but I wouldn't be too concerned about it. And I will follow up with your case manager to find out what the nature of this meeting is. Excuse me. So the very next day, I contacted the WSIB and asked to speak to the case manager on file. The case manager came on the line, and I said, I understand that my client was visited by two individuals from your office, and they weren't very specific in terms of why they were there, even though our client indicated that he is represented, and of course you're aware of that because you and I have had several dealings with respect to this file. So I'd like to know what the nature of that meeting was, and also if there's any information that I can provide that the client may have not been aware of to address whatever concerns you have. And at that point, I was told by the case manager that she no longer had any authorization to speak with me. And I said, okay, well, why is that? I don't believe that my client has given or revoked our authorization for representation. So unless that's happened, you really have no reason to deny that request, as it is a legal document that has been used by my firm for well over 25 years. And she said, well, I have been instructed by our legal department that we will no longer be dealing with yourself or your company. And I said, well, so you have made that decision, your legal department. They've also made a unilateral decision to basically go against my client's wishes, and more importantly, to seize any dealings with my firm. So I believe that an explanation should be provided immediately. Otherwise, we won't have any other option but to pursue legal action on our behalf as well as on behalf of our client. She then proceeded to advise that there was a letter that was being prepared by their legal department that would be coming out within the next couple of days. And I said, okay, well then I will await receipt of that letter. You have my fax number. If you could please fax it to me, I would appreciate it, so that we can address this issue promptly. So within a period of 24 hours, give or take, I received the fax from their legal department. And that letter also indicated that they had sent out 5,000 letters to active clients. Our clientele basis at that time was about 10,000, 5,000 of whom were already archived. These were clients that we had either worked for and were able to secure something, or that we weren't able to secure anything and the file was closed, or it was archived as the matter was addressed at that point, but may need further action down the road. So with respect to the 5,000 letters that they indicated that they sent out, was to active clients. And basically the letter said what the case manager had indicated to me the previous day on the phone, that they had made a decision that they would no longer recognize me personally as a paralegal in dealing with the WSIB. They would no longer recognize my company, Machado Corporation, Machado Paralegals Professional Corporation, nor would they recognize any of my paralegals and other staff within my employ. They indicated that they had conducted an investigation and that the information had yielded that I had falsified information, documents that were provided on behalf of certain clients. So basically at that point, I was somewhat at a loss as to why this was happening. And I wrote a letter to their legal department and to their president and CEO at the time, David Marshall, and obviously vehemently opposed their decision, denied any wrongdoing on the part of my company or myself or any of my staff, indicated that any documentation that had been provided on behalf of any client was consistent with our method of operation over a period of over 25 years, but that it was also part of the process for any other paralegal firm or law firm dealing with the WSIB when information needs to be provided on behalf of a customer or a client, information that sometimes is requested from a third party, whether it be Canada Pension Disability, ODSP, a doctor, Canada Revenue Agency for the purposes of earnings information, long-term disability insurer, EI, employment insurance, disability benefits, even information provided by witnesses that we would have interviewed on behalf of the client when preparing a case to present. So all of this is consistent with our operation, that there was nothing beyond that that had been submitted. And if they were able to prove that to be the case, to then provide that information. But to unilaterally make a decision to go against a client's rights, as they've done, was not only unlawful, but extremely prejudicial to the customer and also to our firm, as we could risk losing millions of dollars in lost revenue as a result of their actions. Excuse me. that letter was sent off to the WSIB, and I waited for a reply. It took about 2 weeks, and the reply came in the form of a visit by 2 individuals from the WSIB. I understand them to be the same individuals that had visited with the clients. One of them is their investigator, and the other one was just some other person within the organization, I guess, that they always send them out into for some reason. Anyway, they came by the office, introduced themselves, gave me their cards, and I walked them into my office, and they sat down. And I said, I'm still waiting for a letter from your company explaining why you've taken a decision to refuse to deal with my organization. And that's causing some significant problems. I have clients that are very concerned with where they're at with their cases. I have many clients who have, as I know, or as I've been told, protested to the WSIB, and apparently that's fallen on deaf ears. But in any event, I'm still waiting for that letter. And what I was told, and the gentleman handed me, I think there was 3 or 4 documents, which came in the form of a summons to appear in court, as they were charging me with fraud for having falsified information. As I'm sure you can appreciate, I was taken back, and I was angry first for how they've acted and how they've conducted themselves in this manner. Obviously, it was a tactic to put fear into the clients, and they've already been through enough. They don't need to be bullied by the WSIB. And I was angry that they hadn't acted in a more direct and expedient manner, so as to allow me to adjust, protect my clients, and take whatever necessary steps required to support my staff. And I was also, in some respects, I kind of had a bit of that aha moment. And I thought to myself, no, that can't be. And I dismissed that thought. But it wasn't entirely gone. So anyway, I said, okay, that's fine. You've done what you came here to do. Now you can leave, and I will do what I need to do to address this matter. So at that point in time, I was in the process well into the initial phase of implementing a project that I had been working on for the period of about 8 or 9 months. Back in the summer of 2014, one of my case managers or paralegals brought to my attention some inconsistencies on how WSIB was calculating earnings in more recent claims under Bill 99. Those types of earnings are called so they have the short-term earnings calculation and the long-term earnings calculation. I'm not going to go into a lot of detail about what that entails, but those cases primarily or exclusively affected clients that we had that were injured on or after January 1st, 1998, when Bill 99 came into effect. So she brought that to my attention. It wasn't the first time. And there were some inconsistencies on how they were doing these calculations from one case manager to another, and also some decisions coming back from the appeals branch. And so anytime that those types of scenarios happen, my case managers would bring it to me so that I could go through the policy and the formulas that they use, and attempt to discern whether or not there were some inconsistencies or whether it was being done properly. Reason being, I don't trust anything the WSIB does. I never have and never will. So we always verify. It's not to say that they do everything wrong. They do a lot of things right, but I never trust them. So anyway, I went through that process, and it turned out that on 3 instances, the calculation wasn't being done correctly. So they hadn't taken all the collective earnings from the different employers within an 18-month period and used them to calculate the long-term earnings. And so in those cases, it resulted in a reduction of the client's benefits, which of course was unfair. So as I went through that, it got me thinking. We addressed that issue, and it got me thinking about how earnings were calculated for individuals who had been injured before January 1st, 1997. So claims that fell under the Bill 162 legislation, which was the period January 1, 1990 to December 31st, 1997, and then individuals that were injured before January 1st, 1990, and after July 26, 1985. And I've done a lot of work in terms of those calculations when I was injured myself. As I indicated in my first video, I took a significant undertaking to learn as much as I could about the laws and policies that governed the legislation at the time that I was injured. And then, of course, through experience and continuing to upgrade our knowledge, I learned a significant amount with respect to how those earnings were calculated beyond January 1st, 1990, as far as Bill 162 is concerned. So I went back and looked at that, and what I found was now, I'm going to preface this by saying that at the time I was reviewing approximately 9,000 to 10,000 customer or claim files. Fortunately, we had a very sophisticated software system that allowed me to go in and do searches and aggregate based on certain items that I put into the system to yield a list, and then I could take that list and go through it and do a more cursory review, and then delete those from that review that I didn't think applied in that particular process that I was affecting. And then I ended up with another list, and through that list, then I actually went and physically reviewed the client file that was on our system and looked for various pieces of information that were actually contained in the WSIB claim file. Fortunately as well, we started the process of automatically scanning the entire client file into our system. And this started probably in mid-90s, mid to latter part of the 90s. I believe we were one of the first ones to do that. It was cost prohibitive, but anyway, we did it. Fortunately, I had my son and one of his friends who needed part-time work. They were teenagers, so they go in the evening with appropriate clearance, and they would just scan files to the system. So it took me a long time to go through these, but what I was looking for specifically was what information the WSIB used to calculate the earnings basis for that claim. So the earnings basis is the formal term that they have in the Workers' Compensation Act that references what the individual will be compensated in terms of all benefits that flow from that. So total temporary disability, partial temporary disability, permanent disability, or in other words, a pension, and Section 147 supplements. So that earnings basis was very important, because that was the information used for all of those calculations in the event that the client became entitled to any one of those benefits. Now, the WSIB would act mostly on the information that the employer provides on the Form 7. So the Form 7 is the accident report. And that's the report that the employer is required by law to complete and provide to the WSIB, with a copy given to the worker within 3 days. And so there's a bunch of information that's being requested, including earnings information. And in most cases, employers provided the worker's hourly rate. I would say that in the thousands of reports that I've reviewed personally, this was probably 80% of the time, that's the information they provided, and nothing more. So that was what the WSIB would use to calculate that earnings basis. You may have also heard someone refer to it as a compensation rate, or the comp rate. So when I started to review the law and policy, and it's very extensive when it comes to that, there are many other factors that can be considered by the WSIB payment department. So this is a very specific area within the WSIB and the payment specialist when they're doing those calculations. Again, through going through that shorter list, going through the client file, reviewing the Form 7, the accident report, to me, there's information that was likely or could have been missing that could apply to that client, that could be useful in yielding a higher rate. And so basically, when calculating that earnings basis, the WSIB can take into consideration 1 year of earnings from the injury employer. If they worked multiple jobs during that, or for multiple employers during that year, they can only consider 1 year earnings from their accident employer, which is fine. But they rarely requested that 1 year earnings. So if the client was earning income from employment, from that employer, which would have been classified a different type of earnings. And I'll give you an example. If the person did regular overtime, for example, or if they did piecework, which was prevalent through the 80s and 90s. If they received a product in lieu of payment, and there's more, and I have an extensive list of that, all of those factors could be considered as part of those earnings. But again, in 75-80% of the cases, that was never provided, and the WSIB never asked for it. And in those cases, in most cases, it's the earnings information, the hourly rate provided on the Form 7. So through my review, as I'm going through the list, I started to check off quite a significant number of clients that could fit the criteria to have their earnings basis recalculated. And I then put together a very special project, or a program, if you will, so that I could, in a step-by-step format, communicate with the client, indicate or ask if there were other types of earnings from that employer that weren't provided in the hourly rate. If they had their T4 slip for that year, that would be very helpful. In fact, that would be the most helpful. And if they had any other records of any income or product in lieu of notice that, or in lieu of pay that they received, to just go through the list and check off the list and then provide that information. So as we started to go down this process, now this would have been, I think, in the latter part of 2014, I had already began to request information from clients. I also received communication back from clients that they didn't have their copies of T4s. It had been so many years ago, some of them more than 20 or 25 years. In fact, in most cases, they were well over 20 years. And so I said, well, listen, the alternative is to request it from the Canada Revenue Agency because they would have that. And so they started to request information from the Canada Revenue Agency. But then I started getting calls that Canada Revenue Agency was saying that they couldn't get the information for months and months, and it would take a long time because they had to go through microfiche or some process. And I said, well, listen, if you want to do it faster, there's likely a faster way to do that. If you go to your member of parliament, they have a designated contact for their constituents within the CRA or to handle issues of this nature, and see if they can get it for you faster, which they did. And then I started getting calls from members of parliament saying, stop sending your clients. Revenue Canada is pissed off at us because it's giving them a lot of work, and they're just going to do it as they can. And I said, well, fine. I mean, that's neither here nor there. The customer is requesting it. If you can help the client, fine. If you can't, then Revenue Canada will do it whenever they have to. But we need this information to proceed with this calculation or recalculation. So in the early part of 2015, I was able to submit, I believe it was 5 of them. And it's important for me to specify that because a lot of these that we were dealing with were 20 years and over, just $1 per hour difference on the worker's recalculated rate paid from the time of injury or from the time benefit started to the present time, which would have been early part of 2015 when the recalculation was requested. That payment with interest would amount to well over $100,000. And that is pretty significant payment, not just for arrears and interest, but also for those clients who were injured before January 1st, 1990, and their pension was for life. That means that whatever pension they were receiving at the time would receive an increase based on the recalculated rate, taking into consideration the indexing factor for each year. And that rate, that new rate, would be their pension going forward until they die. So we're talking about a very significant retroactive payment. And we're also talking what could be potentially a significant increase to future payments. There were quite a number of clients that fit that profile that I had started, but I was just beginning to scratch the surface. If you can imagine, if you just take 200 clients and they have to pay over 100,000 retroactive for those 200 clients, and increased pension rates going forward, do the math. It can amount to billions of dollars, and that's just my firm. When you take into consideration the claims that the WSIB has on the books that are currently being paid and that were being paid at the time, so January or February of 2015 when I started this, if you take that and you look at all of those that were before January 1st, 1990, the WSIB has annual reports they provide, that they're released each year by law, which provides a very clear, specific indication of how many claims were filed, how many claims were denied, how many claims are being paid for permanent disability, how many claims were being paid for temporary total disability, and so on and so on. So if you do that calculation and review those financials for the WSIB, those annual reports, if you take that, and we're talking now hundreds of thousands of injured workers in receipt of those benefits, what happens when they start to figure this out and start requesting that their benefits be recalculated? Now, as a part of my process that I put in place, we always, as a cautionary measure, I always did an internal calculation. The reason being is that there's a downside risk that is stipulated in the law, in the Workers' Compensation Act, that if the worker requests a recalculation of the earnings basis, and that recalculation results in a downward, so a reduction of the benefit that was established, they won't go back and collect those funds, but they will reduce it and it'll stay at that level, which is wrong. And I'll explain why. At that point, I had been representing injured workers, my firm, for maybe close to 30 years. And I had never had a manager or a case manager, an adjudicator, a director, a vice president, a payment specialist, all of these individuals that I spoke to on a regular basis. Never, ever was there anything either stated to me or in writing that the WSIB could consider all of these other factors to calculate the earnings basis. So if the worker doesn't know what he or she is entitled to, how are they going to request it? And then once they find out what they're entitled to, which, by the way, you didn't tell them, and it results in a downward calculation, how can you justify penalizing them for that? This is your job. This is what you should have done. You should have asked, the adjudicator should have asked for all of the information that the Act provides for. So whether it's there on the Form 7, if it's not, the case manager or the adjudicator should have contacted the worker and said, listen, did you earn any other income from your employer? Did you do regular overtime? Did you get paid based on shift premium? Did you get paid based on piecework? If you're in a construction industry and you're traveling and you have a hotel accommodations and per diem and all that, did you have these benefits? All of these things. But no, they didn't know anybody. They didn't do any of this. And so to penalize the worker, but anyway, that's their stance. So fair or not fair, as a cautionary measure, I always did that calculation to determine whether or not it would yield an increase to the benefit or not. If it didn't yield an increase to the benefit, I closed the file, sent the client a letter, or called the client and said, listen, I did the calculation. It's not going to result in any increase. I'm sorry, but anyway, we looked at it, and just to be sure, and nothing's going to change. So when getting back to looking at the number that would be out there that could request those recalculations, could result in billions of dollars in arrears payments and payments in increase to the pension. That's a lot of money. And this did not fit with David Marshall's plan. The one that he'd started in 2007 when he was hired by the WSIB to come in and get rid of that unfunded liability. So I like to put a face to a name. You've heard me reference David Marshall before, so I'm just going to put him up here on this corner, or maybe this one. Anyway, there he is. David Marshall was hired by the WSIB, as I indicated before, in 2007. And the main job was to eliminate the WSIB's $14 billion unfunded liability. And basically, that's the difference between the money that the WSIB has to pay out, given the number of claims currently on the books, and the shortfall. So they brought David Marshall in to do that. You can learn a little bit more about him if you just Google David Marshall, WSIB CEO. There's a number of articles, including another article I'm going to post here as well from the Toronto Star about an interview with David Marshall. But anyway, so he comes in and he just starts, cutting everything, and the appeals branch is starting to get again backlogged, and so is the tribunal. It's a mess. What really caught my eye was that even though the government, the Liberal government, had agreed to give them to 2027 to reduce that, to eliminate that unfunded liability, he did that 10 years ahead of time. In fact, he was boasting about it in this interview that he did with the Toronto Star on January 31st, 2015. So 10 years ahead of time. Why so aggressive? If you had another 10 years to do that, did it coincide with his bonus payment that he received from WSIB? What was the real motive? I fail to understand that. Why do it 10 years ahead of time? In the meantime, thousands of injured workers waiting for benefits on the appeal lists. Some of them probably didn't even apply because they knew that they'd likely be denied. But there's another interesting thing that he stated in that newspaper article. And that was done again in January of 2015, that interview. And he indicated that one of the reasons, among several, was that there were fewer claims. But that's not the case. Because if you look at this report, this financial report, or annual report I got from WSIB, which you can get as well. That report shows that for 2013 and 12, 13, 14, there were no reductions in claims. They were all over 230,000. The only one that was 229,000, I believe, was 2015. But that information, those records would have been provided in their annual report a year later. So how did you know that in 2015 there were reduction in claims when he did this interview in January of 2015? He could not have possibly known in any way, shape, or form. So, but even, let's give him the benefit of doubt for that year. And that's only a difference of about 4,000 claims or so. For the previous three that are on the chart, they were all over 230,000. So there were no reduction in claims, period. So I don't know how that factored in to that unfunded liability being eliminated within those 10 years. After about a year and a half, and by this time I had taken all of the necessary steps that I could to place clients with other firms. Most weren't equipped to handle that volume. One of my senior paralegals continued to do some work after that. But about 16 months of dealing with the WSIB's prosecutor, we came to a mediated agreement by the Justice of the Peace. And I'll never forget what he said to me when we had that last meeting. Well, it wasn't the last meeting. I needed to think it over. But anyway, he said, Mr. Machado, you're going to have to make a pragmatic decision. I knew what he meant by that. And I also knew that the WSIB couldn't prove any wrongdoing because I hadn't done anything wrong. But I knew their end game. It was to discredit me in the most public manner so that that whole project that I was working on, the recalculation of earnings basis, that it never see the light of day, that it just be shut down. So I'm a fighter. I've always been a fighter. That's why I decided to help injured workers. And I don't shy away from a fight. But I wasn't about to put my clients and my staff through what I knew was going to happen, and to have their lives turned upside down. And I wasn't about to let that happen. So I did end up making that pragmatic decision. And so on that day, I was both relieved and I was angry. I was relieved that it was over, that my clients and staff wouldn't be harassed, and I was angry as hell that they got the better of me. And I knew full well why. At least my gut told me that, and all of the dots that I connected told me that. So it's been 6 years, almost 7 years. And I've never really talked about this to many people, apart from my wife, my kids, and a couple of very, very, very close friends. But it's time for me to talk about it, and because don't kid yourself. However you feel about what's going on with your claim today and your benefits, be cautious, because they are not any better today, any more friendly to the injured worker today than they've ever been. So was I gone entirely? No. 3 years ago, I decided that I wasn't going to waste all of that experience, the knowledge, the tactics, the moves, the things that I knew, that I'd learned, that worked. I wasn't going to put it to waste. I decided that I was going to go back doing what I was meant to do, what my career was, and that is to help injured workers. Now, I'm not violating the agreement that we made, which was that I would never represent injured workers again, or my company, or any of my staff. But that doesn't prevent me from providing the tools and teaching and the support mechanisms that injured workers could use to defend themselves and to get what they're entitled to within the law. And so I started WSIB Settlements.com. And I created a number of programs. One of the key components of WSIB Settlements.com is our WSIB settlement kits. And basically, these settlement kits are documents that I wrote, no different than the thousands of appeal documents and appeal letters that I wrote over the years. And using the same structure of those kits to provide the proper law policy that applies to the issue being requested or adjudicated, the evidence required, and any other information to be able to address any issue with the WSIB. So our kits can help you deal with an issue from before January 1st, 1990, if you have a pension and if you haven't had a pension reassessment and your condition has deteriorated, we have a kit for that. If you were cut off from a particular supplement that you should have been entitled to receive, we have a kit to help you do that. If the WSIB denied you chronic pain disability entitlement, which is handled in a very specific policy, we have a kit to do that. If you were denied or your spouse was denied attendant care benefits, we have a kit to do that. If you were denied the independent living allowance, and you meet the criteria for a catastrophic injury, we have the kit to help you do that. If you weren't reimbursed for medical expenses, we have the kit for that. We have a kit to help you get a NEL assessment. If you had an injury, you suffered a permanent impairment, and you didn't have a NEL assessment. We also have a kit to help you if you requested a NEL redetermination and it was denied. We have a kit to help you do that. If your loss of earnings benefits were reduced or cut off and you didn't agree with it because they didn't consider the appropriate earnings, we also have a kit to do that. We have a kit to help you handle any and all issues that could come up or that have come up in the last 30 plus years in your claim. Now you're going to ask, well, what if I didn't appeal a particular issue? Or what if I never addressed that issue? We have a kit to help you do that as well. It's called the reconsideration process. In fact, we have 3 kits to help you through that process. Through my system, you have all the support you need every step of the way if you need to have a question answered so that you can make an informed decision. To be able to put one of our kits together, all you need to do is answer 5 simple questions. Any one of our kits can be done in a matter of less than 5 minutes. It's going to take you as long as it takes you to type. If you can type the answers to those questions in 2 minutes and you click Submit Kit, you will have your kit in 2 minutes. That's how simple it is. Because for me, it was important to make it accessible and easy for everyone, regardless of your age, regardless of whether or not you can communicate the language effectively, regardless of your knowledge of the laws, basically regardless of your skills and work experience. If you have a computer, you can access our kits and you can address all these issues with our kits. We also have other tools that are very unique to help you manage your claim. One of them is our tracking system. One of the things that I always found when I was dealing with the claim was the client's inability to recall important dates, whether it was a meeting with a doctor or a specialist or a meeting with the employer or the WSIB or what was said during that meeting. With this tracking system, you can track all of your activities that take place in your claim, and they're secure, they're confidential, and you can access a report or detail of all of those activities in the event that it's needed at an appeal or to deal with a particular meeting, so you have the facts that you need on hand. These are all tools that we used as a firm that made us very, very successful. We also have a kit, it's a process that I call the compression factor. And that one basically addresses the WSIB's inability to align your priority with theirs in terms of how quickly you need to get things done and letting things fall by the wayside. We have a kit to do that. We also have a kit that forces a decision maker, whether it's an adjudicator or case manager, their manager or a director, to look at the issue, not sit and leave it, but to look at it and then make a decision based on the actual law and the policy that applies, and by citing all of the evidence used in making that decision. Because the WSIB loves to make decisions without providing any context to them. Why? Because I believe that they perceived injured workers, me included, as being stupid. We're too dumb to understand things. And then you get frustrated and you give up. To see how simple it is for yourself, you can go online. It's WSIBsettlements.com. We also have videos. We have one there that talks about the kit. It actually shows you how to go through the process of putting a kit together. You can do, there's a sample kit that you can do as well. So you can look at all of that and see if it's of any value to you. The other thing that was important for me was to make it accessible for everyone, regardless of your ability to pay. So in most cases, injured workers pay a retainer fee. They get into a contingency fee with a paralegal or a law firm to handle their claim. And it can be upwards of 25-30% of the settlement. And I can tell you from experience, that can amount to thousands of dollars. And you know what? That's fine. I mean, I'm not saying that's not a viable option. We did it. And in fact, my firm started the contingency process because it didn't make sense for me to try and charge hourly to people that weren't earning, couldn't pay, and then just rack up this bill. So I figured we'll go on a contingency basis. If we win, you pay us so much percentage. If we don't win, I foot the bill. I pay for all the expenses. It doesn't cost you anything. So we started that. But I wanted it to be affordable. I wanted this process to be affordable, and I wanted to empower you to be able to handle your own claim successfully with the tools and the support mechanisms that we have in place. And to make that affordable, it's only $17.95 per month subscription fee. That's it. It comes off your debit or your credit card once a month, $17.95. And you have access to all of our kits and all of our tools and all of the support that we can provide you with. So I encourage you to have a look, take some time, and then you can decide if it's something that works for you or not. So that was one step that I took 3 years ago to start to build and put together the pieces that I believe were necessary to continue to help and support injured workers. Also, if your case is such that we believe would merit the involvement of a lawyer or a paralegal, that's okay too, because we make that referral. But we've already pre-vetted, we've already looked at the particular lawyer or paralegal that becomes one of our service providers to make sure that they have the necessary experience, expertise, and resources to be able to effectively manage and deal with your case, whether it's an appeals branch appeal or a tribunal appeal. There is a rate for that, but that's obviously a member rate, which would be less than what you would be paying somebody right now. So that's one step. The next step for me was important was to start this channel, WSIB Truth Matters with Joe Machado. What is the purpose for this channel? So I looked at how can I help? How can I be of more assistance beyond what we already provide through WSIBsettlements.com? So it's going to begin with, it's a twice a week video release on Sundays at 7 p.m. Eastern Standard Time and Wednesdays at 7 p.m. Eastern Standard Time. My videos are going to be anywhere from 5 to 15 minutes at most, depending on the content that I'm providing and how important it is to a large segment of our subscribers. During those episodes, if you will, I'm going to talk about the benefits in more detail under the 3 different payments schemes. So before January 1st, 1990, which would be largely under Bill 101, between January 1st, 1990 and December 31st, 1997, which falls under Bill 162, and then all of the claims and that scheme, payment scheme, from January 1st, 1998 to present. So I'm going to cover those 3 and get into details. And if you've had multiple claims that fall under 2 of the different payment schemes, or even 3 of the different payment schemes, and I've seen those, believe it or not, I've had those cases, then you can tune in to the 3 videos and you'll be able to see and get some real factual information about how it works and how one or the other may impact your benefits and or if you're being paid properly. I'm also going to talk about matters that are being requested by subscribers. So if you have a particular issue that you're having or that you had years ago that you don't think was handled properly and there's some questions lingering about that, then send me an email with that question, and I'm going to answer those on the Wednesday videos. Now, if you're not able to watch this, it's not a live video, so you don't have to go on Wednesday, but you can watch it at any time because it'll be there on our video catalog on YouTube. I also want to do interviews with fellow injured workers. Over the years, I visited with a lot of injured workers and their families. And there's many instances that come to mind where we were able to help the family, but I never got to meet the injured worker because he or she had passed away before their case was settled. That's I think the worst thing one of the worst visits that I could make, because not knowing that your family is going to be looked after is horrendous. So yes, I want to do interviews with subscriber injured workers or their families. Again, you can send me an email. Tell me a little bit about yourself, and then we'll connect about that. Another thing that I'm going to be doing is I'm going to go through, and I used to do this a lot, and so did my staff, and I taught them to do that regularly, and that is to go through WSIB, or Workplace Safety and Insurance Appeals Tribunal decisions. So these are decisions that are made by an external agency, independent of the WSIB, but their decisions have the power to overrule WSIB decisions. So we would go and research decisions, and we would go through certain decisions that would meet or that were similar to a particular issue we were having. And so there's a lot of decisions out there that could be very beneficial for you to learn about, so that there may be scenarios that you can compare and say, I was in that situation. Maybe I should have this issue addressed. So I'm going to be reviewing those decisions and providing an analysis on them as well. Anyway, I don't know what else I can do with that channel, but I think that most of it will be based on what I've just talked about, and it can evolve into more. So anyway, friends, I want to thank you for taking the time to review, to listen to me. I know this video was a little lengthier than the other two, but I couldn't cram this into a shorter video, and I didn't want to put out another video to go and talk about this again. So bear with me. I hope you got through to the end and you watched the whole thing. And please subscribe and share with others. You know, if you have friends, have family who've been injured on the job, you know, and maybe they'll subscribe, and this can help them in some way. You know, give us a thumbs up, you know, if you like what you heard. But by all means, you know, comments. I will be reading your comments as much as I can, and responding to them as well. Anyway, thanks again for tuning in, for listening. I hope to see you again in our future videos, and I'll see you on Sunday when I release the next video. Take care.